This is a review of BLLE Chapter 39, Labor Management Relations. After reading this chapter, we should understand the following: how collective bargaining was resisted for many years in the United States and how political economic changes resulted in the legalization of labor unions, the four major federal laws in the United States. We should also understand the process by which bargaining units are recognized by the National Labor Relations Board, and the various kinds of unfair labor practices that employers might engage in and those that unions and their members might engage in. Traditionally, labor law opposed concerted efforts and activities by workers like strikes and picketing and refusal to deal to obtain higher wages and better working conditions. At various times, all of these activities, they were found to be or constitute criminal conspiracy or tortious conduct and even violations of antitrust law. Eventually, public pressure in response to the adverse treatment accorded to labor forced Congress to intervene. Over a half a century has the federal law of labor relations developed out of four basic statutes into a huge body of cases and precedent that regulates the formation and governance of labor unions and the relationships among employers, workers, and union members. Pretty much, labor law is central to the operation of every business. Unions started popping up in modern form in the United States around the 1790s in Boston and New York and Philly. Employers began to seek injunctions from courts trying to keep the unions from organizing and engaging in other activities. Employers tried to use a number of common law doctrines to support their arguments, including the common law conspiracy doctrine and doctrines on restraint of trade. Common law conspiracy is a doctrine that pretty much holds that workers who came together, they were basically acting as criminals in a conspiracy, and it didn't matter how they were coming together or why they were coming together. Common law restraint of trade, or sometimes referred to as violations of antitrust law, those were used to enjoin workers under the argument that the workers engaged in is a concerted activity that restrained the trade of their labor. Back then, the courts were of the view that an employer was entitled to buy labor as cheaply as possible. And if the workers unionized, then that would raise the price of labor and operate as a restraint on trade. In 1890, Congress passed the Sherman Act, and that's named after a United States senator that pretty much contributed to the writing of that legislation. This legislation allowed certain business activities that were deemed to be competitive to be regulated by the federal government. The law most generally attempts to prevent restraints or restrictions on trade or supply in opposition to competition and capitalism. So in the United States, this is also called antitrust law. The Sherman Act did not really change those common law views or application very much, but what it did do was condemn labor activities as violations of antitrust law. So a number of cases popped up. In the Danbury Hatter cases, the Hatters instigated a boycott against retail stores that sold their products, which were top hats, manufactured by that company whose workers were on strike. The Supreme Court held that a secondary boycott against a non-unionized company was a violation of the Sherman Act. A secondary boycott is basically one that exerts social and economic pressure against the party with whom it deals. It's pretty much a combination of harm by one party to another party that coerces others to harm them in order to get them to yield to the union's demands. But in this case, the union ended up having to be liable for treble damages under the act. Later on, Congress passed the Clayton Act, and that act held that labor unions were not illegal combinations or conspiracies or any restraint on trade under antitrust laws. It also said that courts could not issue injunctions in cases about strikes or boycotts or unionized activities in general, as long as it is between an employer and the employee about their employment. About 10 years later, the Supreme Court struck out against these secondary boycotts again and hindered some of the Clayton Act's provisions. In this case, a mechanics union held a boycott against an employer, but the members of the union were really not employees of the union. They were trying to get the employer to allow one of its factories to be unionized. The Supreme Court said that the Clayton Act's labor exemption only applied if the boycott was between an employer and its employees, and that really wasn't the case there. Not too long after that, Congress enacted the Railway Labor Act and established the National Mediation Board to mediate disputes that were not otherwise settled in contract negotiations. Next thing you know, Congress created more comprehensive national labor laws, starting with the Norris-LaGuardia Act, also known as the Anti-Injunction Bill in 1932. This act withdrew from the federal courts the power to issue injunctions in nonviolent labor disputes. In that legislation, they broadly defined labor disputes to include any controversy concerning the terms or conditions of employment or union representation, regardless of whether the parties stood in an employment relationship, so secondary boycotts were allowed. This act also declared it United States policy that labor was supposed to have the full freedom to form unions without the employer's ability to interfere. This act even went so far as to prohibit yellow dog contracts, through which the employers were coercing their employees into promising that they would not join a union. Later, after that, Congress then enacted the National Labor Relations Act, or the NLRA, or sometimes called the Wagner Act, which is the federal government's big attempt to support collective bargaining and unionization in the United States. The act provides that the right to self-organization, to form or join or assist labor organizations, or to bargain collectively through representatives of their own choosing, and to engage in a concerted activity for the purpose of collective bargaining or other mutual aid or protection, is for workers going to be a federally protected right. The NLRA basically gave employees the right to union representation when negotiating employment terms with their employers. The NLRA also sought to enforce the collective bargaining right by prohibiting certain employer and union activities deemed to be unfair labor practices. So, for example, the NLRA identifies these activities to be unfair employer activities. So, interference with the employee's right to unionize and bargain collectively, the domination of the union, the discrimination against union members, discrimination against employees that have filed charges or testified under the NLRA, and a refusal to bargain in good faith with duly established employee representatives. The National Labor Relations Board also was established by the NLRA as the federal administrative agency that has the power to investigate and remedy unfair labor practices. And of course, at some point, there has to be some case that comes about. So, the Supreme Court later on, in another case, upheld the constitutionality of the NLRA in a few cases, the biggest one being the NLRA versus Jones and Laughlin Steel Corporation. This case involved a union dispute with management. The NLRB said that Jones discriminated against their members, and Jones said the NLRA was unconstitutional and that Congress did not have the constitutional authority to legislate over unions. The Supreme Court, applying a less strict construction approach, meaning that modest impacts on interstate commerce were reachable by federal legislation, held that the act was narrowly constructed to regulate industrial activities that potentially would restrict interstate commerce. Based on that approach, the Supreme Court ruled that Congress's commerce power does extend to activities that might affect the flow of interstate commerce, as labor relations definitely have such an effect. So the NLRA placed restrictions on the employer. You can imagine how many unions were formed after that. So to keep things a little bit balanced, Congress then needed to place some restrictions on unions so they didn't get out of control. So Congress passed the Taft-Hartley Act, even over President Truman's veto. This legislation did not repeal the protections given to employees under the NLRA, but it did prohibit certain unfair union practices and separates the prosecutorial and adjudicative functions of the NLRB. So this legislation amended the NLRA by declaring the following 7 union activities of the NLRB to be unfair labor practices. So first, coercing an employee to join a union. Second, causing an employee to discharge or discriminate against a non-union employee. Third, refusing to bargain in good faith. Fourth, levying excessive or discriminatory dues or fees. Fifth, causing an employer to pay for work not performed relating to feather bedding. Sixth, picketing an employer to require it to recognize an uncertified union. And 7th, engaging in secondary activities. A secondary activity, like I've already mentioned, is like a boycott, strike, or picketing of an employer with whom a union has no labor dispute to persuade the employer to cease doing business with the company that is the target of the labor dispute. So, for example, assume that the California Teachers Association is engaged in a labor dispute with SBVC. To coerce SBVC into resolving the dispute in the union's favor, the union organizes a strike against KVCR, a company with which CTA has no dispute. Then CTA agrees to stop striking against KVCR if they agree to stop doing business with SBVC. The strike against KVCR is a secondary activity prohibited as unfair labor practices. This legislation also established the Federal Mediation and Conciliation Service to deal with strikes that create a national emergency, and it declared strikes by federal employees as so illegal, super illegal. This legislation also prohibits closed shops, but it does allow union shops unless a state right-to-work law prohibits union shops. A closed shop contract are those that require the employer to hire only union members. A union shop contract permits the employer to hire non-union members, but it requires the employee to become a union member within a specified time after they get employed and to remain a member in good standing as a condition of employment. A right-to-work law is a statute that prohibits a union shop contract, but most states do allow the existence of union shops. And this legislation also reinstates the availability of civil injunctions in labor disputes if requested of the NLRB to prevent an unfair labor practice. The act also empowers the President of the United States to get an injunction for an 80-day cooling off period for a strike that is likely to endanger the national health or safety. And then, of course, we have the Labor Management Reporting and Disclosure Act, also known as the Landrum-Griffin Act. This is one that aims at eliminating corruption in labor unions. This legislation tries to eradicate corruption through an elaborate reporting system and a union bill of rights designed to make unions more democratic. Now that we've gone over the 4 major types of legislation that apply to labor law, let's look at the NLRB a little bit more closely and see about their organizational structure and purpose. The NLRB has 5 board members that are appointed by the President and confirmed by the Senate. They serve 5-year terms that are staggered, and the President will select the chairman and appoint the General Counsel of the NLRB. The General Counsel for the NLRB heads the board's investigatory and prosecutorial functions and represents the NLRB when they have to go to court. They also get to oversee regional offices across the states. As you can see here, our district is highlighted in California. The function of this body is to investigate allegations of unfair labor practices and provide remedies. They also are able to select which unions will serve as the exclusive bargaining agent for a particular group of employees. And as you can also see here, there is a chart that shows how many charges were filed in a particular year, how many settlements occurred in that particular year, and how many complaints were issued by the General Counsel. So how does it work when you're trying to go through the unfair labor practice cases? So of course, it starts with somebody having a dispute. So there's some unfair labor practice that occurs and there's a dispute about it. That person must report the charge. Charges must be represented or presented to the board because they don't have the authority to initiate lawsuits by themselves. After the charges are reported, then an investigation ensues. The charges are investigated at the regional level, so they may issue a complaint. If they do not issue a complaint, then that decision may be appealed to the General Counsel and their decision is going to be final. If a complaint is issued, then there's a few things that could possibly happen. There's either going to be a case or there can be some mediation. So there is an elective NLRB ADR program that complainants may participate in. If they do not elect to do that, or even if they do and still want to continue with litigation, then the NLRB administrative law judge will hear the case. They give a decision, and that decision is going to be subject to review by the board. After that, a complainant can appeal by filing exceptions. If they do file those exceptions, then the board will review the case. Generally, at least 3 members of the board will make a decision. If the complainant still isn't really satisfied with the outcome, that person may appeal to the United States Court of Appeals, and then after that, they can appeal to the United States Supreme Court. Now let's look at some labor management rights under the federal labor laws. As it relates to selecting the union as the exclusive bargaining representative, it can get a little bit complicated. So, if a union has a contract with an employer, then a rival cannot try to get elected to kick out the established union except within 60 to 90 days before their contract expires. They cannot also hold an election if an election has already been held in the bargaining unit during the preceding 12 months. The union represents employees, and the NLRB has the authority to determine which employees will comprise the appropriate bargaining union. They look at their wages, their skills, their duties, their working conditions, and so on. Certain groups have to be excluded from any bargaining unit, which would include supervisory employees and independent contractors, which is why Dr. Briggs has the circle line across her, because she is in a supervisory position and is not covered by the union. The NLRB decides what employees are supervisors. As it relates to communication, employers have an interest in protecting their property rights. They have an interest in managing the business efficiently and profitably. Employees also have a right to communicate with each other, with the public, and with their union. So there are some general ground rules to balance each of those parties' interests. These rules include the following. So if there are persons doing the soliciting that are not employees, then the employer may bar them from entering their private property, even if they are attempting to reach employees, assuming that the employer does not discriminate and they apply that rule in an even-handedly way against the use of its property unequally to everyone. Another rule, if the solicitors are not employees and they are trying to reach the public, they have no real right to enter the employer's private property. If the solicitors are employees and they are seeking to reach the public, then they do have a right to distribute on the employer's property. In a common case, maybe a shopping center, unless they have a other convenient way to reach their audience on public property off of the employer's premises. If the solicitors are employees seeking to reach other employees, then the employer is permitted to limit the distribution of literature or other solicitations to avoid litter or the interruption of work, but it cannot prohibit the solicitation on company property altogether. Now, let's take a look at the employer's duty to bargain. The NLRA holds that both the employer and the employee have a duty to bargain in good faith. So let's look at a few examples. Let's say that Valley College is engaged in a labor dispute with the CTA. Valley College says, hey, we can talk about it, but I will be damned if I pay any more. And then me, on the other hand, I say, run me my money. Clearly, money is the central consideration to the labor dispute. Is this a breach of the duty to play nice or a breach of the duty to bargain in good faith? And it is not. This is SBVC's statement of the company's position. Only SBVC's actual conduct during the negotiations will determine whether there is a breach of the duty to bargain in good faith. What about this one? If SBVC says, I refuse to deal with you, and of course I maintain my position, is this a breach of the duty to bargain in good faith? And the answer is yes, it is. Another one. If SBVC says, I will have complete control and I will not accept your terms, and of course I maintain my position, then is this a breach of the duty to bargain in good faith? And it is not. The Supreme Court held that an employer is not obligated to accept any particular term proposed in a collective bargaining agreement, and the NLRB may not second-guess any agreement that is eventually reached between the parties. The NLRB requires employers and unions to bargain over the terms and conditions of employment. These are some mandatory subjects of bargaining. Wages, hours, working conditions, whether the workers must wear uniforms, when lunch starts, when it ends, things like that. But that statutory phrase, terms and conditions of employment, is pretty vague and it's not really defined, and it may be difficult to figure out whether a particular employment term is within those confines. Case law suggests that the management gets to determine the scope and direction of its enterprise, so those types of terms will be a non-mandatory subject, and the union cannot require that an employer bargain over it. And once a term is incorporated into the collective bargaining agreement, neither side can demand that it be renegotiated during the term of the agreement. If you want to see an example of a collective bargaining agreement, you should be sure to go to the slide deck and actually click the collective bargaining agreement listed here for the California Teachers Association. Also, keep in mind that a mere refusal to bargain or agree is not bad faith bargaining. An employer may refuse to accede to a union's demand for any reason other than an unwillingness to consider the matter in the first place. If a union cannot convince that employer to accept their demands, then the union has plenty of other actions at their disposal to use. The NLRB cannot compel an agreement even if management acts in bad faith, since the parties are free to bargain.
Now, let's turn our attention to some methods an employer probably should not use to interfere with or discriminate against union activity. We've already mentioned how a company can limit union activity or communication on company property. But to review, an employer cannot make a rule that unilaterally prohibits union members' ability to distribute union literature during quote-unquote working time or quote-unquote working hours. But the employer is within their power to only allow the distribution of literature to happen during the employee's free time. If that distribution of literature takes place while the employee is actually working, then an employer can issue a rule against that type of distribution, and the courts will usually presume that that rule is valid. Even if an employer has such a rule, the NLRB maintains the power to enjoin, aka stop, the enforcement of that rule if the employer was using the rule to cease union communication but allowed other types of communications to take place, kind of like communications for maybe charitable causes, for example. Or we can think about it like this. Working time is for actual work. That's the whole point of having a business. So an employer can have and enforce rules that limit the solicitation and distribution during that time, so long as the enforcement of that rule is non-discriminatory, and so long as they are not prohibiting employees from talking about or soliciting for a union during non-working time, kind of like before or after work or during breaks. Employers also cannot interfere with unions or avoid their union obligations by relocating their business operations to another location. If they do, then that is considered an unfair labor practice, and it's also called a runaway shop. Other types of employer interferences that are considered to be unfair labor practices under federal law include things like hiring professional strike breakers to disrupt a strike, or showing favoritism towards a particular union to discourage another union, or maybe awarding or withholding benefits to union members to discourage or encourage unionization, or engaging in misrepresentations and other unlawful acts during the union election campaigns. Another unlawful interference includes spying on union workers or making employment contracts with individual members of a union, or even blacklisting workers or attacking union activists physically or verbally. And of course, an unlawful interference would definitely include disseminating various forms of anti-union propaganda. Also under the NLRA, employers cannot discriminate against employees. Unlawful discrimination may take the form of refusing to hire or tenure employees as a means of discouraging employees from becoming union members. Unlawful discrimination may also take the form of employers failing to reinstate employees after a lawful strike or engaging in a discriminatory layoff or lockout of employees.
Now let's talk about the right to strike. It is pretty clear from a reading of the provisions of the NLRA and the NLRB that the law not only guarantees the right of employees to strike, but it also places certain limitations and qualifications on the exercise of that right. So unlawful strikes will include sit-down strikes, wherein the employees stay on the work site, precluding the employer from using the facility. Those are going to be unlawful. Wildcat strikes are also unlawful, and that's when a faction within a union walks out without authorization. Violent strikes, jurisdictional strikes, pretty unlawful. Secondary strikes and boycotts are still unlawful under this act. So these are strikes or refusal to handle goods or threats, coercion, restraints, and other actions that tries to force any person to stop doing business for another producer other than the employer, or to stop doing business with the employer. And of course, strikes that are intended to force the employer to sign a hot cargo agreement would be unlawful as well. As it relates to lockouts, to combat the power and effect of strikes, especially when many employers are involved with a single union trying to bargain for better conditions throughout the industry, an employer may resort to a lockout. Typically, the union can call a whipsaw strike, striking some of the employers but not all of them. The whipsaw strike puts the pressure on the struck employer because their competitors are still in business. The employers who are not struck may lawfully respond by locking out all of the employees who belong to the multi-employer union. This is known as a defensive lockout. In several cases, the Supreme Court pretty much ruled that an offensive lockout, which occurs when the employer anticipates a strike, it happens when the employer locks those employees out, and it's also permissible under the law. So let's look at an example. Suppose that the California Teachers Association puts up a picket line around the SBVC walls in order to force that company to recognize the union as the exclusive bargaining agent for SBVC's instructors. The instructors themselves do not join in on the picketing, but when a delivery truck shows up at the school's gates and discovers the pickets, it turns around, it turns back because the driver's policy is never to cross a picket line. This activity falls within the literal terms of Section 8B4. It seeks to prevent the employees of SBVC suppliers from doing business with SBVC. But in a certain case called the NLRB versus International Rice Milling, the Supreme Court held that it is a primary activity, and this type of activity is not unlawful because it is directly aimed at the employer involved in the primary dispute. Let's look at another example. Suppose the CTA strikes SBVC. The non-union managers who also instruct refuse to cross the picket line. So SBVC sends out its classes to RCC, a school in Riverside, to do the instructing job. When the strikers learn what SBVC has done, they begin to picket RCC, at which point RCC's instructors honor the picket line and refuse to enter the premises. RCC then goes to court to enjoin or stop the pickets in exception to the Norris-LaGuardia Act that permits the federal courts to enjoin the picketing in cases of unlawful secondary boycotts. Should the court grant this injunction? It might seem so, but not in this instance. Under this doctrine called the Ally Doctrine, the court will not grant that injunction. Since RCC is joined with SBVC to help finish the work of instructing, the courts are going to deem the second employer an ally or extension of the first employer. So the second picket line, therefore, is not secondary. Let's look at another example. Suppose that despite the strike, SBVC manages to ship its finished product from the culinary students to the Mission Inn, a restaurant in Riverside, which sells a variety of goods, including food. The union puts up a picket line around the Mission Inn, and the picketers bear signs that urge shoppers to refrain from buying any SBVC products at the Mission Inn. Is this an unlawful secondary boycott? And the answer is no. There is a provision that does permit publicity aimed at truthfully advertising to the public that products of a primary employer with whom the union is on strike with is being distributed by a secondary employer. But let's change the facts a little bit. Suppose that the picketers carry signs and orally urge shoppers not to enter the Mission Inn at all until it stopped carrying SBVC goods. Now that would be completely unlawful. A union may not picket a secondary site to persuade customers to refrain from purchasing any of the secondary employer's products. Likewise, the union may not picket in order to cause the secondary employees, which would be the workers at the Mission Inn, to refuse to go to work at the secondary employer. That is a classic example of inducing a secondary work stoppage, and it is barred by the Act. However, in a certain case called DeBartolo, the Supreme Court opened what may prove to be a significant loophole in the prohibition against secondary boycotts. Instead of picketing, the union distributed handbills at the entrance of a shopping mall, asking customers not to patronize any of the stores in the mall until the mall owner in building new stores promised to deal only with the contractors paying fair wages. The court approved the handbilling, calling it only an attempt to persuade customers not to shop at the mall, distinguishing that from picketing, and we all know that picketing would constitute a secondary boycott. This concludes our review of this chapter. If you have any questions, please feel free to send me a message in Canvas or ask me after class.